Good morning. My name is Malcolm Neekirk. Welcome to Fretton's 5th coffee break briefing of this year. Today I'm going to be talking about fixed charge receiverships. Now this is another refresher topic. Don't expect anything very new, but I hope it will still be useful for you. I'd like to say thank you to all who attended our first annual insolvency conference last month. I hope you enjoyed it as much as I did, and whether you were there or not, I hope you'll join me and my colleagues for our second conference next year. Details to follow. We're in the process of choosing dates and venue and so on. We'll let you know as soon as we can when that's likely to be. So this morning's theme is fixed charge receiverships, what they are and when to use them. These are the topics I'm going to cover this morning. I'll be looking at the underlying concepts behind fixed charge receiverships, the use that you can make of them and what the alternatives might be. I'll be looking at different types of receiverships, and then I'll be moving on to look at the process of appointing receivers and finishing off by looking at the powers that fixed charge receivers typically have. So starting with the underlying concepts, fixed charge receivership is a form of security enforcement. That's its history, that's what it is primarily there for. And it's where a mortgage lender appoints a third party, a receiver, to take possession of the mortgaged assets. So the requirements here are you need a loan, a lender and a borrower, and you need a valuable asset owned by the borrower. That's usually land, but it's not always. You can have fixed charge receiverships on other types of property. I've seen fixed charge receiverships over debts or intellectual property, over the goodwill of a business, a number of different assets, but it is almost always land. And the borrower will have granted security over that asset to the lender. And the lender is able to appoint the receiver once the borrower has gone into default. And of course, it is the lender who then has to find this third party, somebody who is qualified and willing to act as a receiver. Now, receivership is for commercial loans only. You're not able to appoint a receiver of somebody's private home. Just cannot do that, but almost any other type of property you can appoint a receiver of. The receiver themselves, they will be selected and appointed by the mortgage lender. They are largely unregulated in the sense that there is very little statute law that deals with receivership. There's a fair amount of common law, judge-made law, but you normally have to be stepping into quite exciting territory before you need to start looking at that terribly closely. And fixed charge receivers do not have to be insolvency practitioners, and indeed very often surveyors or other property professionals act as fixed charge receivers. The appointment is an informal one, by which I mean it's simply done by paperwork. It doesn't involve courts, judges, or learned friends. It's an appointment that the lender can make as of right. And an important concept here is that the receiver is the agent of the borrower, the party in default, not the lender. And that seems quite surprising, and it is quite difficult for people who are not familiar with receiverships to come to grips with. I'll say a bit more about that. What the agency means, for example, is that the receivers will make contracts in the name of the borrower, not the name of the lender and not their own names. And so, for example, when they are selling the land that's covered by the mortgage or other mortgaged assets, they will be selling it on behalf of the owner of the land, the borrower, and that's the name that will appear on the contract. The agency also means that, as a general rule, the lender is not responsible for what the receivers do. It's not their issue. And one other effect of the agency is that it does end automatically upon the borrower becoming bankrupt or going into liquidation. Now, that doesn't mean that the receivership ends or that the receivers have no powers from that time. It just means that the receivers from that point onwards are acting as principal. They're no longer acting as the agent of the lender. And the other situation that you need to be a bit careful about, in fact, lenders need to be a bit careful about, is that the receiver is supposed to act with independence. And if the lender interferes too much, has too much involvement in making decisions on behalf of the receivers, then the agency that the receivers have may come to an end, and they may be regarded as effectively acting on behalf of the lender, which is a useful argument for telling an overbearing lender just to step back and let the receivers get on with the job. So that's the underlying concepts. Let's look at some of the uses and of receivership and the alternative that there may be. The primary use, of course, is enforcement of security, and it is an alternative to the lender taking possession. So the lender would have the right to take possession, but instead they choose to appoint this third party to act as receiver instead of them doing so. The advantage for that is that the lender does not become mortgagee in possession. And as mortgagee in possession, lenders do have certain legal responsibilities and duties, and by appointing a receiver, they avoid, to a considerable extent, taking on those responsibilities. Another advantage is that it subcontracts a job that lenders don't normally do. So it brings in outside expertise and resources. The lender themselves, their primary job is not going to be managing the properties of their borrowers. So it's useful to bring in somebody else to do that for them. And by actually having somebody else doing that work, again, it to some extent insulates them from legal liabilities, because the receivers have at least a professional responsibility to do a proper job for what they're doing. Another advantage is that it avoids using the courts. As I've said, the appointment of receivers is informal. It's just done through paperwork. There's no judges involved, no application to the court. And there are a number of mortgage lenders who, as a matter of policy, do not like to take possession without having a court order. So appointing a receiver avoids delay, expense, and can be a convenient way of them securing their interests. And another practical use I have often seen for receivers is that they can very often mediate between the borrower and the lender. If there's a difficult relationship there, as there very often can be, then sometimes appointing an independent third party, although they will be seen as being, well, as working for the lender, nevertheless, they can often open new lines of dialogue, and those insolvency practitioners who enjoy mediating, who enjoy solving disputes and bringing people together, can often do a really useful job in reducing the temperature and finding a solution that is in everybody's best interest. Other less obvious uses for receivership. First heading I've got there is asset preservation, and this involves putting the secured asset in the hands of a third party to make sure that the right decisions are being made. The very first receivership I got involved in, which I was trying to work it out before I started this, it must be more than 35 years ago, was one that was in that category. That was a nursing home owned by a partnership of two, and the two partners had fallen out with each other dramatically and irreconcilably. They were no longer speaking to each other. The poor manager of the nursing home was getting conflicting instructions from the two partners about what she was supposed to do to run the business. And the lender was becoming very concerned that the reputation of the nursing home was suffering badly, and that it was heading towards a point where there was going to be a formal default and a big problem for the lender. So the lender appointed fixed charge receivers simply to take control of the asset and to take it out of the hands of the warring factions. I have to say that wasn't an entirely smooth transition. I think in that case the receiver was the subject of an injunction from one of the disgruntled partners within 48 hours of their appointment. But nevertheless, the business kept trading, and it took 6 to 12 months to achieve it, but the business was sold, and for a decent price. So that's one possible use. And that brings me on to the other use that I've seen for fixed charge receiverships, is actually to resolve disputes of that sort. And they can be really useful if you've got an internal power struggle, deadlocked companies, or serious partnership disputes. If you have a mortgage lender who's prepared to roll their sleeves up and get stuck in to try and sort that out. Alternatives to fixed charge receiverships, well, administration is one, and although most of this morning's presentation, I have at the back of my mind that the borrower in default and over which you are to be appointed a receiver is a company. It needn't be a company, it could be a sole trader, it could be an old-fashioned partnership, and old-fashioned partnerships, of course, are able to go into administration, as well as companies being able to go into administration and LLPs going into administration. So that might be one alternative. Second alternative, if there's nothing terribly complicated that needs to be done with the property, liquidation might be absolutely fine. And very often you might find that actually repossession by the lender is the simplest solution. And I have seen receiverships, in fact, where the purpose of the receivership has primarily been to allow the lender to take possession. And what has happened there is the lender has appointed receivers, receivers have taken possession, secured the property, done everything that needs to be done immediately on taking possession, and then after 3 months or so have simply handed the keys over to the lender, who has then dealt with the continuing low-level management of the property and its sale. And of course, it's worth remembering that fixed charge receivership can sometimes be an alternative to procedures such as these as well. So let's move on now to look at the types of receivership. Just to make it clear what I'm talking about in terms of fixed charge receivership. And broadly speaking, there are two types of receivership. There are the contractual receiverships, those where lenders have appointed receivers, such as fixed charge receiverships. And then there are court-appointed receivers, where a party with an interest has gone to court to ask for the court to exercise its discretion to appoint a receiver. If you're asked to take appointment as a court-appointed receiver, it's really important to make sure that you get the order drafted right from the outset, because the only powers that you will have will be the powers given to you in that court order. So it is crucial to make sure that they are right from the outset, and that you get, I'd normally suggest getting the learned friend involved, a suitably experienced barrister to help with the drafting of that. And as a court-appointed receiver, you do need to make sure that your remuneration is secure. And there are two aspects to that. The first one is to make sure that the court order makes provision for you to be paid on an acceptable basis and sufficiently frequently. And court orders are sometimes deficient in that regard. And the second one is to remember that ultimately the only asset over which you are likely to be appointed, unless you're being appointed by a secured creditor, the only asset over which you're likely to be appointed is the equity in the assets after deduction of any interests of secured creditors. And I have seen court-appointed receiverships, fortunately not ones where I've been acting for the receiver, but I have seen it happen where the receiver has done a valuable and lengthy job and has then found, perhaps 18 months into the receivership, that the secured lender has chosen to enforce their security and has essentially whipped all of the assets out from under the feet of the receiver, leaving them with nothing left under their control, and crucially, no assets with which they can draw their fees. So remuneration in a court-appointed receivership is very important. The second type of receivership are the lender-appointed receivers, what I'm calling, in its broadest sense, fixed charge receiverships. And there, the powers that you will have will be some extremely limited statutory powers. Ideally, you will have some additional contractual powers given to you by the mortgage deed, and those can be really extensive powers. In the past, until 2003, administrative receiverships were quite common. I'll say a bit more about those in a minute, but now they are largely banned, and they actually form a bit of a bear trap. You need to make sure that you are not accidentally appointed as an administrative receivership, because if you are, your appointment will be invalid. And it's worth mentioning that if you are invalidly appointed as a receiver, then you are not a receiver, you are a trespasser. You are there without any entitlement to be there, and the company is entitled to claim compensation for any damage that you have done to its interests. So it is important to make sure that you are effectively appointed. Just saying a bit more about court-appointed receivers. As I've said, one use of court-appointed receiver is business protection. There are statutory appointments of receivers in the field of criminal law enforcement. I won't be talking about those. And the other situation in which you can have a court-appointed receiver is to enforce security. And this can be useful if the extent of the powers that are offered to you in the mortgage deed are wholly inadequate, and you might think then about asking the court to appoint you as a receiver and to confer additional powers on you when they do so. I'll also mention there writs of sequestration, which I think are now called writs of confiscation. And this is a penalty for contempt of court. They were particularly newsworthy for those of us with long memories, late 70s and early 80s, particularly in the context of industrial relations, where trades unions would break the law, very often with something like illegal secondary picketing. They would have an injunction taken out against them to stop them from breaking the law. They would carry on doing so in breach of the injunction, which would put them in contempt of court. And the most effective way that was then discovered of forcing the unions to comply with the law was to issue a writ of sequestration and appoint sequestrators, who I think are now called commissioners, who would go in effectively as receivers to take possession of the union's assets, its bank account, its offices, and effectively remove the management of the union temporarily until they gave an undertaking to stop breaking the law. So that's looking at different types of receivers. Let's say a few more about LPA receivers and fixed charge receivers. I'm using the phrase Law of Property Act receiver, LPA receiver, to refer to those who are appointed with only the statutory powers. And those are the statutory powers conferred by the Law of Property Act of 1925. They are extremely limited. There's very little that you can do as a pure LPA receiver. So most LPA receivers, as called, are actually what I would call fixed charge receivers, and they are appointed with additional contractual powers, very often quite extensive additional powers. The appointment may also include assets that are caught by a secondary floating charge, as well as the fixed charge on the property. It's quite common for a mortgage deed to include not only a legal mortgage on the land and the buildings, but also a floating charge on all of the contents of the land. So if you've got a legal mortgage of that sort over a business such as a shop, then the fixed charge will cover the land and the building, and the floating charge will include all of the shop fittings and the stock in trade of the shop as well. And that would give a receiver potentially the power to trade the business in receivership. Watch out that that's not an administrative receivership. I'll say a bit more about that in a moment. And it's also possible for a floating charge, for example, a floating charge on book debts, to be crystallized into a fixed charge and effectively take control of those book debts. And then the lender can appoint a receiver of those book debts to take possession of them and collect them. Let's move on to say a bit about administrative receivers. The definition of an administrative receiver from the Insolvency Act is a receiver who is appointed under security that includes a floating charge. It's often a battery of fixed and floating charges, but there has to be at least one floating charge in there. And all of the charges together under which the receiver is appointed have to cover substantially the whole of the company's undertaking. And if that is the situation, then you will be an administrative receiver, and that will be generally not permitted except in very, very limited circumstances. So you do need to watch out for an accidental appointment. So take the example I gave earlier of a shop where the lender took a mortgage over the land and the buildings and a floating charge over the contents of the shop. Now, if you are appointed under that security, and that is essentially the only asset that the company has got, it's just got this one shop and its contents and nothing else, you could be appointed as an administrative receivership. If, on the other hand, the business has 2 or more shops and you are appointed as a receiver of only one of them, then you won't be an administrative receiver. It's not always easy to tell. Those of you who came to our conference last month will have heard Philip Ridgway's excellent talk on tax and insolvency. And one of the things that he talked about then was synthetic administrative receivership. I'll move on from that because I've essentially just covered that. But synthetic administrative receivership is where you have an overseas company that is operating a business in the United Kingdom. And as such, they can grant full security to their lenders, including a debenture, which includes a qualifying floating charge. Any receiver appointed under that full security will be broadly equivalent to an administrative receiver with all of the powers of an administrative receiver. But because it is an overseas company, they don't fall within the statutory definition of an administrative receiver, and so therefore that appointment is valid. And finally, just a reminder here of what I've already said, that in appropriate circumstances, a secured lender, rather than appointing a fixed charge receiver themselves, can go to court to ask for that appointment to be made. And the advantage of doing that is that the court can confer additional powers on the receiver at that point. So let's look at the appointment process. And this is not a court-appointed receiver. This is a normal fixed charge receivership. The first part, the first stage of this, is in some ways the most important: investigation and planning. And what you will need to do, as well as deciding what the strategy is likely to be for the receivership, you will need to get the security checked to make sure you've got a valid mortgage, to look at what security you have got other than the legal mortgage on the land itself, and to look at what additional powers you have got, and to think about whether those powers are adequate for the nature of the appointment that you're planning to take. And you'll also need to get the terms of the lending reviewed to make sure that the lender has got the right to call in the loan. And that's the first stage in the formal appointment itself, is the lender making formal demand to call in the loan. And the method for doing that will be as set out in the security documents, and the lender will then have to give the borrower an opportunity to pay the money that is demanded. And it's only when the borrower has failed to pay on demand that the appointment can be made. And that's important. That means that the lender has to wait to give the borrower an opportunity to comply with the demand. And the rules about this are fairly clear. You have to give the borrower an opportunity while the banks are open to call in the money from another account somewhere, if they've got it somewhere else, and transfer the funds. And the courts have said that that requires a bare minimum of 1 hour while the banks are open. So this means that if formal demand is served at, let's say, 4 o'clock on a Friday afternoon, then the fact that the borrower has had it over the weekend is not enough. You have to wait until the banks open at 9:30 on Monday, and then the earliest you can make the appointment will be 10:30 on Monday morning. And although an hour is the absolute legal minimum, I normally say that it's polite to allow at least 2 hours, and in a situation like that, I would be recommending that the appointment is not made before midday. And just going off at a slight tangent, this is relevant to appointments of administrators under their qualifying floating charges as well, because the secured lender holding the qualifying floating charge cannot make the appointment until the debenture has become enforceable. And the debenture will only become enforceable once this procedure of making formal demand, waiting while the banks are open for at least an hour, and then making the appointment. You've got to run through that for an administration as well. And I have seen people not following that procedure. And I think that's wrong. I think that's dangerous. Moving back to fixed charge receiverships, it's now approaching midday. You've got a borrower who is in default. You can now make the appointment. This is done by the lender executing the appointment document and delivering it to the proposed receiver. The receiver has the choice of accepting it or not. Where the borrower is a company, then the receivers can only accept the appointment on the day that they receive it or before close of business on the next business day. And when they accept it, the appointment is backdated to the time and date when they received it. So best practice is to accept the appointment as soon as it is delivered to you, and to liaise with the lender to make sure they don't deliver the appointment to you until you are ready to accept it. So that's the appointment. Let me just talk very briefly about the powers that receivers have got. You do have to look at the charge document because Law of Property Act receivers, with only their statutory powers, have got extremely limited powers. They can collect rent, and that's about it. They haven't even got a power of sale. The other reason for looking at the charge document carefully is to look at what assets are caught by the charges. If there's an asset that you need, but it's not caught by any of the charges under which you are appointed, that asset is outside the receivership and you have no power to use it for the receivership. As I've said, the mortgage deed will very often give fixed charge receivers many more powers than the statutory minimum, and you do need to check what you are being given. Typically, they will be powers to take possession of the property, to sell it, to manage the property, perhaps to complete building work if it's a development site, and perhaps to run the business if it's something like a shop, something of that sort. Now, running a business can be problematical. You may find that you need charges on fixed and current assets, not just the land. You may, going back to the example of the shop, you may well need charges on the stock in trade, pending orders that have been placed by the shop, the fixtures and fittings in the shop itself. And as I've already said, if you've got charges on all of those, you may be stepping into administrative receivership territory, which is not where you want to be. And also the rules about employment contracts under the Insolvency Act are that you will be adopting the employee's contracts 14 days after your appointment. So you'll need to have a clear plan and strategy for dealing with the employees if you're going to be trading the business. So what if in that first stage of planning the receivership, you think that the powers that you've got are insufficient? Well, there are ways of adding to your powers. One would be to ask the borrower for a deed of variation or even an additional charge document. And that can very often be done. The borrower will often recognize that they have run out of cash, that the business is going to have to be dealt with by a third party by one means or another. And they may well regard it as being in their best interests to make sure that the borrower does actually recover as much of their debt as possible, particularly if the borrower's director has given a personal guarantee. They may well be quite willing to offer a deed of variation or a supplementary charge. The lender themselves may have additional statutory powers that the receiver might be able to use, and the lender is able to delegate those powers to its receiver. Or you could seek a court appointment, and if you're going to that stage, you might even be looking at using a different procedure, and you might be thinking that if you've got that much cooperation from the borrower, well, actually administration might be the right way of doing this. And again, this general warning: if you're taking additional security, don't turn your appointment into an administrative receivership. So that's dealt with the main points, the underlying concepts behind receivership, how you might use a receivership, what it might be an alternative for, and what might be an alternative for a receivership, the different types of receiverships, how you appoint a receiver, and what powers a receiver has got. If you have got any questions, please do ask them now. Just have a look to see if I've received any. And I don't. As always, if you want to drop me an email afterwards to ask a question, or if you want to give me a call, I'll be very, very happy to deal with questions that way. And just to remind you now of our next coffee break briefing, if you want to make a note in your diary, Monday the 8th of August, 10:30, and I will be talking about MVL indemnities then. So thank you all very much. And I'll say goodbye and thank you very much for joining me this morning. Thank you.